Yeah, just who?
Who?
She says she knows.
Okay, who pushed it?
I believe it was Dave's friend.
Dave's friend?
Yeah.
No, actually, you believe it was Dave.
Oh, really?
Yeah.
Oh, I'm sorry. I believe it was Dave.
I wish the judge could do that. I wish I could do that.
How-
That's not what you're supposed to say.
How do you know it was Dave?
Because I heard his.
Yeah, I wouldn't answer that question. I wouldn't ask that question of plaintiff's counsel. So we say, oh, it was Dave. Now move on.
Okay, it was Dave. Okay. Did you hear anything prior to being struck in the nose?
Not prior, but I heard afterward.
Move to strike is non-responsive.
I got it out there for the jury.
Why were you out there?
You got it out there. That's
You
beautiful.
went
Now
out there
you
because
just
you
gave
heard
Jennifer her next question. Did you hear anything after?
Did you hear anything after you were struck in the face with a 2x4?
I did. He's.
Ah! Yes or no question. Greg is over here moving to strike already.
Yes.
Yes, you heard something after you were struck in the face. And
What did you hear?
I heard Dave yell, "I got her."
Objection. Starts with an H. It's the
Hearsay.
biggest one. Hearsay. Hearsay. And plaintiff's counsel, can you think of an exception to the, oh, you guys haven't taken evidence yet. Hearsay, let me think if there's an exception. Excited utterance is a good one. Anybody else can think of an exception to the hearsay rule here? Who has taken hearsay? I know I have a couple of number of 2Ls in here, or incoming 3Ls, but we have a couple of incoming 4Ls.
Well,
Oh, you
you
guys
don't
are taking
take
the
evidence.
evidence. You'd have excited utterance, okay, is one of your exceptions to the hearsay rule. When somebody says something in the moment, that's not hearsay. Because they wouldn't have said, you don't say things, you don't lie in the moment. You don't go, oh my God, that plane just crashed. You don't say that kind of thing and lie. You don't lie and say, oh my God, that plane just crashed, like I just did. If I did that right now without any preface, you would all think I'm freaking crazy, right?
Yeah.
We all know.
Okay, so you probably already think that.
At your
But
5150 hearing, we'll put it in.
what's that?
At your 5150 hearing, we'll put it in.
Yeah, but either way, so I, as the judge, will say, objection overruled, it's an excited utterance, you can answer the question. And you answer the question of, he said,
I got her.
I got her. Okay, you've got everything except what now, Jennifer? Damages. Here's how, let me give you a little info on how to approach damages. Go through the temporality of the situation. What happened after the accident? Did you go to a doctor? What doctor, what's his name? What did he charge you? What services did he do for you? Et cetera, et cetera, et cetera. That's where you want to go, okay? Basically, you're telling a story, but you have to ask a question for every sentence of that story. That's what testimony is. They're telling a story, but you're not allowed to tell stories. That's a narrative. What you are allowed to do is get the story out of your client by asking specific questions.
When did you find out you had a broken nose?
Leading.
Okay.
Well,
already
did she
said
say broken nose earlier?
Yeah,
Yeah,
she
she said
did.
broken
That's
nose.
not leading. She already said that.
Yeah. When did you find out you had a broken nose?
Right after I was hit, I felt severe pain on my nose, and I feel like I need to go see a doctor.
Did you see a doctor on
Move to
June
strike
20th?
is non-responsive. She didn't answer the question. You're a pretty crappy witness, Polly. But I told Polly
You
to be a
told
crappy
me to
witness.
be like really difficult. So.
That's the whole point of this. What I would have asked Jennifer is, on this day of the accident, on this date, did you go to a doctor after you were hit in the nose?
On June 5th, did you go to a doctor after
You could even just say,
your
on June
injury
5th, did you go to a
occurred?
doctor?
Did you go to a doctor?
Yes, I did.
And then say,
What was his name?
Dr. Ripoff.
Dr. Ripoff. Hey, that's me.
And what kind medical test did he do? No, that's.
That's leading.
Yeah, that's leading.
That's leading.
I caught
Did he
myself.
do any
Did he do any medical?
diagnosis or what did he do?
What did he do? He
See
went
how
to
that's
see him.
open? Although that could be a narrative, call for a narrative. I would say, did the doctor inspect your nose?
What did he treat you for?
Well, he didn't say, we didn't even know if he treated her yet.
Yeah.
So did the doctor inspect your nose?
Did the doctor inspect your nose?
Yes, he did.
And what are you gonna try to get at next?
What was his diagnosis?
That I have a broken nose.
That you had a broken nose?
Yeah.
What did he do for you?
What's the problem with that?
Is it big?
Did he treat you? Did he give you anything for it? Did he treat you? Did he do anything?
Okay.
Just
Did
don't
he
be so
treat-
ambiguous. It's almost like you gotta play this line, where you're not so specific as to be leading or speculative or bringing in facts, not in evidence, blah, 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 but you also don't wanna be, overly ambiguous. So simply get to the fact that, okay, what did he do after he inspected your nose?
What did he do after?
That's a
he
very good way to
inspected-
question witnesses, is think of it as a story. What did he do first? Oh, he looked at my nose. What did he find? Oh, my nose was broken. What did he do after that? That's perfectly reasonable.
Okay. What did he do after he inspected your nose?
Yeah, but it's my time.
He put a splint on
Send
it
me away.
and
Send me home.
send me home.
Did he prescribe medication?
Yes.
What's the name of the medication he prescribed?
Vitamin.
Like
That's what they would give you.
How long did you take the medication?
Wow, like 6 months.
Broken nose. What else would you want to
Is
get
that when
at?
it-
Well, I'll say like he did a plastic surgery to reconstruct my nose. How's that?
He did, no, we don't want to say that. We don't want to say that. That's
Oh, never
not,
mind.
no. He gave you a splint, sent you on your merry way, and
Did you, how did you feel with the splint on your nose?
why do we care?
Because that could lead to emotional damage or
Oh,
something.
God.
There you go.
Emotional damage and PI. Good
Keeps
luck.
being made fun of.
Good
Maybe
luck.
she's a
Good
student.
luck. Everybody's like, emotional distress comes in emotional distress cases where people intentionally cause you to suffer emotional distress. They screw with you. Personal injury, good luck. But what you probably want to get into is the number one thing here is
How much did? Is that
I love
okay?
it.
Okay.
You're getting there.
Okay. How much did the doctor charge you to examine your nose?
$50,000.
Was that what you were expected to pay, or?
Why would you get into that?
Huh.
Stop there. You're done.
Well, the insurance might have paid like
It doesn't matter.
45 of
Doesn't
it.
matter. Doesn't matter. You got what you wanted out. You're done.
Okay.
Thank you, Polly.
Okay.
Nope. I get the cross.
Yeah.
Yeah.
Okay. Thank you.
You said
You said
Jennifer
thank you,
would still
Polly.
say thank you. Why did I stop you? You got out that Polly's nose was hit in the head, that this guy yelled out, got her, that she got hit in the face, she suffered a broken nose, and then she went to a doctor and it cost 50 grand. You laid your case out. Now, obviously, it would take much more time and a lot more questioning, but we need to move on a little bit. So, Greg, how are you going to tear this witness in half?
Oh, you have no idea. Let's start with the first fact is that.
Start with the first fact as, hi, Polly, my name is blah, blah, blah. Thank you for coming in today. Be polite. Hi, Miss Plaintiff.
Yeah, it's always informal that way.
And oftentimes, if it's in a deposition or even a trial, sometimes like a mini trial, when I come up as to do cross, I say, hello, Miss Plaintiff, do you understand that you're still under oath? That's one of the things I lay out. Okay, so start there.
Hello, Miss Plaintiff. My name is Greg Pruitt. I represent the defendant. Are you doing okay today?
Yes.
So,
Objection, relevance.
phrase it on the thing there.
You know, you can do that. I actually said that to, I was in this really heavily contested divorce case one time.
Yeah.
My own.
Yeah.
More than
Every
one,
divorce
more
case
than
is
one,
heavily
more than one heavily contested divorce case in my career, probably about 100 so far. And I said, thanks for coming in today, how are you today? And the other attorney goes,
that's okay.
objection, relevance, Your Honor. And the judge goes,
Really?
really?
It's
Just
just
trying to be
just courtesy.
courteous. I mean, come on, man. But anyway, get on to your questions, though.
Ms. Plaintiff, you understand you're still under oath, yes?
Yes.
Okay.
You don't say that. You don't say yes. That's leading.
I'm
You're allowed to
I'm allowed to lead.
Yeah, but that's almost like you're giving them the answer. Don't say yes after this.
Okay.
You understand you're under oath, correct?
All right. So on June 5th, you